Hi, I'm Anna Denton-Jones of Refreshing Law Limited, and in today's session I wanted to talk about the Scottish case that's been to the Supreme Court and has given us a ruling, now a decision, on the Equality Act and the protected characteristic of sex. When we are talking about that protected characteristic, we're very clear now from the court that that is biological sex. So the sex that somebody was born with is what Parliament had intended to protect when it created what was originally the Sex Discrimination Act. Separately, in the Equality Act, we have separate protection, or separate protected characteristic for gender reassignment. So an individual who is trans, who is living in a different sex to the one that they were born with, whether or not that's sort of certified with a gender recognition certificate, they have the ability to claim that they've been discriminated against in the treatment that they have received, for example, in the workplace. And by keeping that legal distinction, I understand and can follow, having read it, the legal logic to how the judges got to that place. And essentially what they've done is they've battered it back to Parliament to say, if actually society decides that the law should be different, then Parliament are going to have to change the wording of the legislation so that we can then enforce that legislation. With my emotional heart hat on, I find it deeply concerning for people in the trans community, particularly members of my family who are trans, that the wrong message may be being discussed in terms of emboldening people who don't agree with diversity and inclusion agendas to not recognise the rights of people who do live in a different gender to the one they were born with, or actually that might be the wrong terminology, the gender that is recognised on their birth certificate, because trans people might say that actually they felt that they were always the gender that they're living in. It's just that their piece of paper reflects the wrong thing. The significance of this in the workplace is primarily going to hit around, of all things, the use of the bathrooms. So the Equality and Human Rights Commission has issued an interim update, and if you're acting for an employer, I would suggest you read the full update because it's not very long, which relates to single-sex toilets, single-sex washing and changing facilities, and the guidance that now they're very clear that a trans woman, so biologically male, shouldn't be being permitted to use a woman's toilets or facilities, and vice versa. So a trans man, biological woman, shouldn't be being permitted to use the men's facilities. And the reason why they say that is that at the point that you start allowing the trans person to use the facilities, so if they were to use the facilities where the gender they're presenting themselves in, then those facilities are no longer single-sex facilities. However, it goes on to say that trans people should not be put in a position where there are no facilities for them to use. So that gives service providers, employers the option of providing mixed sex facilities. And if they do that, they have to provide potentially lockable rooms for changing, not just cubicles. Practically, in lots of organisations where space is limited, how are you going to comply with this? I suspect we're back to the days of trans people being directed to use, for example, a disabled toilet that is used by anyone. If you're old like me, then you'll remember the case law on that, probably 20 odd years ago now, where actually asking the trans person to use the disabled facilities was a separate act of harassment, because that trans person would say, well, I'm not disabled, so why should I be using the disabled bathroom? So I'm sure that that point is going to rear its head again. So I think the decision, as is often the way, the judges make the decision based on the legal ins and outs and the legal arguments. They are not thinking about how we live in the real world with these decisions and how employers are going to address those ramifications of what they've decided. So if you have got members of staff who are living in a different gender to their biological sex, then please reach out to those individuals with a metaphorical arm around them, because I think there is a feeling of real damage having been done by this decision, and that it is a step backwards compared to perhaps the position that we thought we were in, and just be aware as an employer that you are on a tightrope, because you're juggling those people who will find this decision the right one and will be very happy about it, that it's clear that, for example, single sex facilities, a swimming pool, only women can go in the women's changing room, and that a trans man is not going to be entering into that space. Balancing that with those who will feel quite vulnerable as a result of the decision, and that there aren't safe spaces for them to do something as simple as use the bathroom. So watch this space. There's bound to be much more flowing from the decision. If you've got any questions, adenton@refreshinglawltd.co.uk.